Hi, a very warm welcome to one and all the aspirants. Thank you very much for your great response and support. And I am apologizing for the delay in publishing this particular lesson, that is the powers and functions of Supreme Court. So now, without wasting any time, we will start this lesson, that is the powers and functions of Supreme Court. This is the third part of the lesson Indian Judiciary. Is it clear? Now, before starting this lesson, I would like to tell you something. That first thing, this lesson is going to be a little bit lengthy, maybe some 35 or 40 minutes, and I cannot break this lesson into two parts. And the second thing is that you have to be very attentive and concentrated, because there are so many important things which might be looking like very minute points, but they are really important. So you need to be very much attentive and concentrated. So let's begin the class. Now, first we'll discuss about the functions of Supreme Court, then we'll move on to the powers of the Supreme Court. Now, coming to the functions of the Supreme Court is considered as the interpreter of the Constitution, and it is the final interpreter of the Constitution. Now, why we are saying that Supreme Court is the final interpreter of the Constitution? Why? Because it is the Supreme Court which has been given the power to interpret the Constitution. This has been done so because Supreme Court consists of so many knowledgeable, expert judicial lawyers or advocates. They are having keen knowledge about the Constitution. They can understand all the judicial terminologies used in Constitution. And there are so many clauses, so many laws in our Constitution which are not very easy to understand by the layman, and it is difficult to decode some of the clauses mentioned in our Constitution. If we take the recent example that the right to privacy is an integral part of the fundamental rights or not, that was the basic question, and that was a question regarding the Constitution. So who interpreted that particular question? It was interpreted by the Supreme Court. So Supreme Court in this way is interpreting the Constitution. Supreme Court in this particular case said that the right to privacy is an integral part of fundamental rights. That means right to privacy is also a fundamental right. So in this way, many times Supreme Court has interpreted the Constitution in giving an explanation or giving the clarity about some of the provisions of the Constitution. So Supreme Court is the final interpreter of the Constitution. That is the first function of Supreme Court. Coming to the next important function of Supreme Court, it guards the Constitution. Hence, Supreme Court is the guardian of the Constitution. Now, why we are saying Supreme Court is the guardian of the Constitution? And what do you mean by guardian? Before explaining this point, I would like to ask you, who is the custodian of Constitution? Now, what is the basic difference between custodian and guardian? You should understand this. Why I am explaining you this? Because there was a question in preliminary examination that who is the guardian of the Constitution. Now, the custodian of the Constitution is none other than the President of India. Is it clear? Now, what is the basic difference between the custodian and the guardian? Let me explain. See, here guardian means that person who guards, or that body which guards. So guardian means a particular body which is protecting something. Is it clear? Whereas President of India is the custodian of our Constitution. Now, what do you mean by custodian? Custodian means nothing but caretaker. Is it clear? So President is the caretaker of our Constitution. That means President is the custodian of our Constitution. Is it clear? Now you have understood the basic difference between guardian of the Constitution and custodian of the Constitution. Now you shouldn't get confused regarding this. Clear? Now coming to the point that we are saying that the Supreme Court has the function of guarding the constitution. Understood? Now, in what way Supreme Court is guarding the constitution? Let us say the government or any other state government or any other public authority is violating the provisions in our constitution through the law made by the parliament or through the action taken by that particular public authority, then it becomes the duty of the Supreme Court to validate whether that particular law is constitutional or not. And how it validates whether that particular law or act is constitutional or not? The tool in the hands of Supreme Court is judicial review. So, judicial review is the tool in the hands of Supreme Court so as to look into the act or the activity that has been done by a public authority, and if the Supreme Court finds that that particular law or provision is violating the constitution, then it says that that particular law is ultra vires, unconstitutional, null and void. That means that particular law cannot be implemented. So Supreme Court is having this power of judicial review. We will discuss about judicial review in the coming slides, so don't worry. So through using judicial review as the main tool, Supreme Court is guarding our constitution. So the second function of Supreme Court is to guardian the constitution. Is it clear? Now the third important issue is that Supreme Court is considered as the final court of appeal. Now what do you mean by final court of appeal? See, basically there will be a lower court and a high court, and basically there will be Supreme Court. Above high court there will be Supreme Court. Now there is an aggrieved person, he is having some problem and he needed justice, so he went to the lower court and there he didn't got any justice. Then from there he moved to high court and even there also he didn't got the justice. Then from high court he moved to Supreme Court. Now Supreme Court has become the final resort of his justice. So it is the Supreme Court finally where a person can appeal for justice. Is it clear? So that's why Supreme Court is considered as the final court of appeal. Is it clear? Now let's talk about the fourth function of Supreme Court. Now it is the function of the Supreme Court to guarantee the fundamental rights to the citizens. Now how the Supreme Court is guaranteeing the fundamental rights to the citizen? Basically the constitution is guaranteeing the fundamental rights to the citizen, but there may be cases when the state is more powerful, that means the government is more powerful and it is imposing some laws on the people which are violating the fundamental rights. Then in that particular case, what will Supreme Court do? Through the provision of writs, constitutional writs, the aggrieved person will move to Supreme Court where he will file a petition, or let us say the writ called habeas corpus. So through this particular constitutional writs, the Supreme Court will validate the entire thing, will investigate the entire thing, and then it will decide whether the fundamental right is being violated by that particular law or act of that state or that particular government or not. And if that particular fundamental right is found to be violating, then what happens? Then Supreme Court directs that particular public authority or the state to act in such a way or to change that particular law in such a way so that the fundamental rights of that particular person or the fundamental rights of the citizens are not violated at all. Is it clear? So through the tool of constitutional writs provided under Article 32. Is it clear? Provided under Article 32. The writs are provided in Article 32 and these writs are the tools in the hands of Supreme Court so as to guarantee the fundamental rights to the citizens. Is it clear? So these were the functions of the Supreme Court. Is it clear? Now we will move on to the powers of the Supreme Court. Basically, we can classify the powers of Supreme Court into advisory powers and supervisory powers. And we will discuss all those things clubbed together. So let's move on to the powers of Supreme Court. It's very important. Basically, these are the powers of the Supreme Court. They are also called the jurisdiction. Why we are calling the jurisdiction and the powers of Supreme Court equal? Why? Because first of all, jurisdiction means the extent to which the Supreme Court has the authority to trial the cases or to discuss on those particular things or to delegate a particular judgment on that particular issue or not. Is it clear? So jurisdiction is indirectly implying the power of Supreme Court. So that's why we are calling it jurisdiction. Now, first we are going to discuss about the original jurisdiction. Then we are going to discuss about the writ jurisdiction. Then the third one is appellate jurisdiction. Then the fourth one is advisory jurisdiction. And the fifth one is the court of record. And sixth one is power of judicial review. Now we'll discuss all these powers one by one. Now, original jurisdiction. So what do you mean by original jurisdiction of Supreme Court? See, there will be some disputes between the central government and the state government, one or more state governments on one side. So if such a dispute arises, or let us say there are some other disputes where the center is on one side and one state or many states are on the other side, then a dispute may arise, and that particular dispute and another dispute where three different states are there on three different sides and they are fighting for a particular cause. In such a situation, when all these three kind of disputes arises, then the entire power of resolving these kind of disputes lies in the hands of Supreme Court. Okay, so in such a particular case, Supreme Court has the sole right to decide such a particular case. No other court can decide such disputes. It is only the Supreme Court which can decide such dispute. Is it clear? And the power to hear such disputes in the first instance is given to the Supreme Court. That means if such a dispute arises, then that particular dispute will not be taken to the lower court. It will be taken directly to the Supreme Court. Is it clear? And not by way of appeal. What do you mean by not by way of appeal? As I have said that when all those three disputes which I have explained here, if these three disputes arises between the center and the state governments, then in such a case, that particular dispute will be appealed in the Supreme Court in the first instance, and that particular case will not be either taken to the lower courts or the High Court. It will be directly taken by the Supreme Court. That means there is no place for appealing. There is no choice for appealing. So not by way of appeal, that particular dispute is resolved not by the way of appeal. Is it clear? So when all these three components are there, that means Supreme Court has the sole right to decide such disputes, to resolve such disputes. No other court can decide such disputes, and the Supreme Court has the power to hear such disputes in the first instance, and that too not by the way of appealing. Is it clear? So all these powers denote the exclusive original jurisdiction of Supreme Court. Do you understand? See, what I have finally explained in this particular thing, that exclusive original jurisdiction is given to the Supreme Court. Okay, and it implies that Supreme Court has the sole power to resolve all the disputes between the center and the state, and those disputes I have explained. So this is the power of the Supreme Court to decide or resolve the disputes between center and state. Is it clear? And there is one more important thing, that see, before we have adopted constitution, if there is any dispute, then such particular disputes cannot be entertained by the Supreme Court. That means pre-constitutional disputes will not be entertained by the Supreme Court. Is it clear? Now what do you mean by pre-constitutional disputes? Before the enactment and the adoption of our constitution, before the Constitution of India came into force, if there were any agreements or if there were any treaties those treaties or agreements are called pre-constitutional treaties or agreements. If there is a dispute regarding such pre-constitutional agreements or treaties or pacts, in such a case, Supreme Court does not have power to resolve those particular disputes. Now, okay, after the enactment of the constitution or after the constitution came into force, whatever the disputes are there between the central government, state government and other state governments, such disputes will be resolved by the Supreme Court. Now, who will resolve those disputes which are considered as pre-constitutional disputes? Okay, so pre-constitutional disputes are resolved by President. Is it clear? So President is the authority who will resolve the cases which have arisen out of the pre-constitutional treaties. Is it clear? Now we'll move on to the next important power of Supreme Court. Now the next power of Supreme Court is writ jurisdiction. Now what do you mean by writ jurisdiction? See, as I have earlier mentioned in the functions of Supreme Court, that Supreme Court is the guarantor or the defender of fundamental rights. And I have also explained to you that how Supreme Court protects or defends or guarantees the fundamental rights to the citizens by issuing writs. Is it clear? By issuing writs. And there are certain constitutional writs. Those particular constitutional writs are habeas corpus, which means you may have the body, mandamus and prohibition, and the fourth one is quo warranto, then the fifth one is certiorari. And what are these particular writs? We will discuss about these particular writs in a separate video. So these writs are different writs through which the Supreme Court, by issuing these particular writs, it ensures that the citizens are guaranteed the fundamental rights. Is it clear? And under Article 32, these particular constitutional writs are mentioned in our constitution. Is it clear? Under Article 32. Remember this point. Now, coming to the appellate jurisdiction, what do you mean by appellate jurisdiction? See, there is a particular process of appealing regarding a particular case. Okay. See, if there is an aggrieved person, that particular aggrieved person will first move to the lower court, which is the district court. And if he feels that that particular lower court didn't deliver justice to him, or if that lower court feels that this particular case is a crucial one and it can be appealed, then that particular case can be appealed in High Court. Okay, so the case will move into High Court. Now it is under the hands of High Court to decide the case, to trial that particular case and deliver the justice. And if that particular aggrieved person feels that the justice hasn't been delivered to him, then he will move to Supreme Court. Is it clear? So Supreme Court is the final court of appeal, as I have mentioned in the functions of Supreme Court. Now Supreme Court is a court of appeal. Is it clear? The aggrieved person who wants justice, he will move finally to the Supreme Court to get justice. But there is a particular process. There are some cases in which particular procedures are mentioned, that how a particular person can appeal regarding a particular case in Supreme Court. Now, hearing appeals against the judgments of lower court is the basic function of Supreme Court. But these appeals are made in different conditions, and those conditions are classified into different matters. Okay, so some issues fall under the constitutional matters, and some issues or some cases fall under the civil matters. Some other cases or issues fall under the category of criminal matters. And there is one fourth important thing, that is appeal by special leave. This is a very special way of appealing. So for appealing the issues which come under the constitutional matters, there is a particular procedure, and for those matters which come under the civil matters, appealing those cases from lower court to High Court, from High Court to Supreme Court, there is a particular procedure. So for every case which falls under different categories of these particular three matters, whether it is constitutional, civil or criminal, these particular matters have different procedures to appeal. Is it clear? Now, what are the constitutional matters, what are the civil matters, what are the criminal matters, and what is the procedure of appealing? Let us discuss. Now, this particular appellate jurisdiction is mentioned in Article 132 of our Constitution. Make it clear, and it is not very important, but just have it in your mind that Article 132 is that particular article which is explaining about the appellate jurisdiction of Supreme Court. Now, here there are constitutional matters, civil matters and criminal matters. Let us discuss about them. First, we will discuss about the civil matters. Now, the civil matters are discussed in Article 133 Clause 1. Is it clear? Article 133 Clause 1. In this particular article, the civil matters are have been described. Is it clear? Now, what are the civil matters? See, whenever an appeal in civil case is being given, means an appeal in civil case on any judgment of High Court can be made only if the case involves substantial question of law, and in the opinion of the High Court, the question needs to be decided by the Supreme Court. Okay, that means, let us say, I will give you an example so as to understand that whatever I have told you, you can easily understand it. See, there is an aggrieved person. He moved to lower court for justice regarding some issue which falls under the civil matter. Let us say he had a quarrel with his relative and they both had a great fighting between them, and his relative has punched him a lot and took over the property, or something has happened like that. Then that particular aggrieved person has moved to lower court, and now the lower court has given some judgment, and that aggrieved person felt that justice has not been done to him. Now, from there, from the lower court, that particular aggrieved person will move to High Court. Okay. When that particular case came into the notice of High Court, the trial will begin. And if the High Court feels that there is a substantial question of law in this particular case, what do you mean by substantial question of law? Substantial question of law means nothing but this particular issue is something which needs to be interpreted in a very judicially perfect manner. Then High Court feels that there is some issue in this particular case which has to be dealt very carefully and it cannot be vaguely judged. So that particular case involves some question of law, means there is a particular law in our constitution which is saying something else, whereas in this particular case whatever has happened in such a way that it is as per the law only, but the aggrieved person is facing injustice. Now, in such a case, if High Court feels that such a special situation is there, that means a substantial question of law is there, okay, then the High Court will refer that particular case and to Supreme Court. Okay, so now the aggrieved person can move from High Court to Supreme Court. Okay, here the High Court will give a certificate. Okay, it certifies that the aggrieved person can appeal in Supreme Court, and after getting the certificate only that particular aggrieved person can move to Supreme Court, and that particular case will be tried in Supreme Court. Is it clear? And whatever the judgment given by the Supreme Court, it is the final. Okay, so under civil matters, what is the procedure? An aggrieved person can move from lower court to High Court, and if the High Court certifies that the case involves substantial question of law and it can be appealed in Supreme Court, then only that particular case will be appealed in Supreme Court and the Supreme Court will hear the case. Otherwise, nothing of that sort will happen. Is it clear? Now let's move on to the next important case, that is criminal case. Now see, under criminal matters, the procedure of appealing has been mentioned in Article 134. Which article? Article 134 is dealing with the criminal matters and the procedure of appealing in criminal matters. Let us say there is a case which comes under the criminal matters, And in that particular case, an appeal can be made to the Supreme Court in 3 different situations. What are those 3 different situations? The first situation is that if the High Court reverses the order of the lower court, that means there is a case in High Court and the High Court has reversed the judgment given by the lower court and then sentenced that particular accused to death. Okay, there was a case in lower court and lower court has given some punishment, or let us say lower court has said that that particular person is innocent. But again that case has been appealed in High Court and now High Court has reversed the judgment of lower court. And now High Court is saying that that particular accused person is a criminal and he has been awarded death sentence by the High Court. Then in such a particular case, this particular case can be appealed in Supreme Court. Is it clear? Now the second situation is that if High Court has withdrawn a case from the lower court and sentenced the accused to the death. Okay, that means a case is under trial in lower court and no judgment has been given yet. But still High Court has taken that particular case from lower court as it felt that that particular case is of great importance. So it has withdrawn that particular case from lower court and High Court has trialed that particular case and finally it has sentenced that particular accused person to death. In such a case, the aggrieved person can move to Supreme Court. Okay, so this is the way of appeal in criminal matters. And there is a third situation. Okay, in the third situation, if High Court certifies that the case is fit for appeal in Supreme Court, then that particular aggrieved person will move to Supreme Court and trial will begin in Supreme Court. Is it clear? So, under these particular 3 situations only, a criminal matter can be appealed in Supreme Court. Is it clear? Now, let's move on to the next important thing, that is appealing, the procedure of appealing in constitutional matters. Okay, so whenever a particular case is there which falls under the constitutional matters and how those particular cases can be appealed, those procedures are mentioned under Article 133 clause 2. Okay, under 133 article clause 2, the constitutional matters, the cases related to the constitutional matters and the way by which those constitutional matters can be appealed in Supreme Court is mentioned. See, what are constitutional matters? Constitutional matters are something, let us say there is a case, for example Keshwanand Bharti case. That particular Keshwanand Bharti came and said that whatever the law has been made by the Indian government, it is violating my fundamental rights and I need justice. Okay, so now the case has turned into a constitutional matter because there is a provision in our constitution and there is a law which has been made by the parliament and it is also in the constitution. But now the question is that because of that particular law, that particular person's justice is being violated, that particular person's fundamental right is being violated. Now that is a constitutional matter, and such a constitutional matter is having a substantial question of law and it can be interpreted by Supreme Court only. So in such a case, what happens? The person can move to Supreme Court and Supreme Court will decide what is that particular case and what judgment has to be given. It will be taken care of by the Supreme Court itself. Is it clear? So these kind of constitutional matters are appealed in such a way that if there is a case in lower court and if the lower court has given some particular judgment, then it's okay. And even then also the aggrieved person can move to High Court, and if High Court finds that there is a particular question of law, substantial question of law in that particular case, and that too, that particular question of law is related to the constitutional, means constitutional matter, at that particular time the High Court will refer that particular case to Supreme Court and Supreme Court will trial that particular case. Is it clear? Then these 3 were clear. We have discussed about the way of appealing in the constitutional matters, the civil matters and criminal matters. But now comes the special and very important point. Appeal by special leave. What do you mean by appeal by special leave? See, this is a very important one. Concentrate here. Appeal by special leave means nothing but appealing by special permission. Is it clear? Appealing by special permission. Okay. So now what do you mean by appealing by special permission? Let us say there is some case which is having something interesting and it is taking place on under special circumstances. I will give you an example. A case was there in Madras High Court regarding Jayalalitha and there were corruption charges on her, and she requested that the case should not be handled by the Madras High Court as it will have so many problems. Then the Supreme Court has transferred that particular case from Madras High Court to Karnataka High Court, and entire trial took place under the purview of High Court of Karnataka. Now Supreme Court has the power to transfer that particular case from High Court of Madras to High Court of Karnataka, and Supreme Court can do this in any part of our country. Is it clear? Now this particular appeal by special leave has been mentioned in Article 136. Okay, under Article 136 this appeal by special leave has been mentioned, and Article 136 explains that if any case does not fall under the constitutional matter, does not fall under the category of civil matters, and it even does not fall under the category of criminal matters. That means there is a case which doesn't fall under these three particular matters, then such a particular case can be appealed in Supreme Court by special permission. So that is called appeal by special leave. Is it clear? But remember one thing. Here the judgments or the order given by any court or tribunal can be appealed in Supreme Court by this appeal by special law provision. Okay, appeal by special leave provision allows any person to appeal in Supreme Court regarding the judgments given by any lower court or any tribunal or any particular constitutional body. Okay, in such a particular case, that particular aggrieved person can move to Supreme Court by appeal by special leave provision. But there is one exception. The exception is that whatever the cases are there in martial court. What do you mean by martial court? Martial court means there is a separate judicial court for the military purposes. Whatever the crimes or whatever the issues take place in military purview, then what happens? Those cases are exceptionally dealt by the martial court, that is the military court. So whatever the cases are being tried under the military court and whatever the judgments have been given by that military court, those particular judgments cannot be appealed in Supreme Court by the provision of appeal by special leave. Is it clear? This is the one and only exemption under appeal by special leave. I hope you are clear with all these three matters. If you are not able to understand this, if you have any question, you can post that particular question in the comment box. I will definitely answer you, and if you can rewind this particular lesson, you can easily understand what I have taught. Is it clear? Now let's move on to the next important point. Now the Supreme Court is also having advisory jurisdiction. Now what do you mean by advisory jurisdiction? Here advisory jurisdiction means Supreme Court has the power to give advice to the President regarding some important issues. Okay, I have explained advisory jurisdiction simply in just one sentence, but it is not enough. There are so many provisions, there are so many issues. Let us discuss them in detail. Now, Article 143 says that President can seek the opinion of Supreme Court regarding any question of law or fact of public importance. Is it clear? So, President is having the power to seek the opinion of Supreme Court, and that particular issue has been explained under Article 143. It is very important to remember this article. Now, how you can remember this particular article? If you don't mind, I'll give you a small example just for fun and just for remembering the fact I am giving this particular example. Don't take it seriously. Okay. In these days, the youngsters, to propose their love, they will just use a code word saying, if they want to say I love you, they will use 143, because I alphabet is only 1, so 1. So 4 means 4 alphabets, LOVE, love. Then 3 alphabets means YOU, I love you, 143. So youngsters use this particular article means number 143 to express their love, okay, to say I love you. So in this way you can remember that President is saying I love you to Supreme Court, and in this way he is seeking the opinion of Supreme Court. So this is a just joking and silly note by which you can understand and remember this particular article 143. So jokes apart, now we will come into the lesson. So article 143 says that the President can seek the opinion of the Supreme Court regarding some important issues. Now what are those important issues? Now see, the President, if he seeks the opinion of the Supreme Court, then in some cases it is not necessary for the Supreme Court to respond and give its opinion. And there are some other situations where the Supreme Court has to give its opinion, means it is must for the Supreme Court to provide its opinion. Now what are those situations? Let us analyze. On any question of law or fact of public importance, if the President seeks the opinion of Supreme Court, let us say there is some question of law or there is some question of fact which is of public importance and it has already arisen or likely to arise. That means it is likely to arise in future, or let us say it has arisen. In such a case, if President asks the Supreme Court to give its opinion, let us say that the some government, I will not name the government, some government is trying to say that cow is a holy animal and nobody kill it. Nobody can kill it. So such a particular law it is going to bring into the parliament. Now it has not been enacted, okay, it has not came in our parliament for discussion. That particular bill didn't came in our parliament for discussion, but still the President feels that it is a matter of public importance which can have serious consequences. So before it can come into parliament, I have to take a decision regarding that. I should have a proper idea about that, and the only person who can guide me in this particular issue is Supreme Court. So he will ask Supreme Court for an advice regarding that particular question under article 143. In that particular situation, the Supreme Court may tender the advice. That means the Supreme Court may give his opinion, or it may also refuse to give opinion. Okay, so the Supreme Court has the power to refuse to give the opinion, or otherwise it can give the opinion regarding that matter of question of law. Now there is the second incident or the second condition where on any dispute arising out of any pre-constitution treaty, agreement, covenant or engagement, if the President asks the opinion of Supreme Court, then the Supreme Court must give its opinion. As I have explained you earlier that what is a pre-constitutional dispute, that is a dispute regarding any pre-constitutional treaty, agreement, covenant or engagement. If such a dispute is there, who will deal with that particular dispute? It is the President. But President doesn't have, or he may have or he may not have the expertise to deal with that particular situation. Of course, he needs guidance, and Supreme Court is a guide to President. Now, Supreme Court has to give its opinion if President asks the opinion of Supreme Court regarding any dispute arising out of any pre-constitutional agreement or treaty. Is it clear? In such a case, Supreme Court must give its opinion. Is it clear? Okay. And remember that always whatever the advice given by the Supreme Court to President, it is not binding on the President to implement it. Okay. There is no rule that the President should implement that particular advice. It is not binding upon the president. Okay, it is only advisory in nature. It is not a judicial pronouncement. It is not a judicial pronouncement. Is it clear? So hence, the opinion of Supreme Court is not binding on the president, and president need not implement the every advice given by the Supreme Court. So this is the advisory power the Supreme Court has, and the sum of the exceptions in that particular power. Is it clear? Now we will move on to the next one. Now another thing is that Supreme Court is called a court of record. Supreme Court has the power to record all its proceedings, activities and judgments that are taking place in Supreme Court. So that's why Supreme Court is called a court of record. But what do you actually mean by referring the Supreme Court as a court of record? See, Supreme Court records all the judgments, proceedings and acts. Let me give you an example. If a case is under trial, then in that particular case, both the defense lawyer and the other lawyer will have a debate, or they will have some questions and answers regarding that particular case. So every question and every answer is recorded in that particular document by a stenographer. Okay, why it is done so? Even the judgment is also recorded in such a way. So each and every detail is being recorded, and each separate file is being maintained for each case. Okay, so it is done for the purpose of perpetual memory. Now what do you mean by perpetual memory? Such a file which contains the activities, proceedings of Supreme Court and the judgments of Supreme Court will be useful for the judges to deal with some other similar cases in future. So those particular records are being used as evidences. Is it clear? So those particular recorded cases are having evidentiary value, and whatever judgments are given in that particular Supreme Court and those particular judgments are recorded. So if the same judgment is given for a similar case, then that particular judgment cannot be questioned before any court. Okay, if such a particular case which is recorded, it is produced in dealing a particular case in any other court, then the court cannot say that this particular judgment cannot be taken as a witness or cannot be taken as an evidence. The court cannot say. Okay, and these particular recorded things can be used as legal precedents and legal references in dealing with some of the cases. Is it clear? Now let us move on to the next one. Now Supreme Court is also having the power which is called contempt of court. So contempt of court is also a power in the hands of Supreme Court. So what is the purpose of this particular contempt of court? Let me first explain to you what is contempt of court. Contempt of court is nothing but if a particular person disobeys the order given by the court, or if a particular person is not obeying the directives given by the Supreme Court, or if a person is intentionally obstructing the daily affairs of Supreme Court or the administration of Supreme Court, or if a particular person is scandalizing or just insulting these particular judgments of Supreme Court, and he is everywhere going and giving speeches the Supreme Court is a corruptive bank and that and this and that. So in such a case, that particular activity will be taken as contempt of court. Okay, so going against Supreme Court can be taken as contempt of court. Recently there was an example. There was a justice who was a judge. His name is Karnan, Justice Karnan. So that particular fellow, what he did is that he always criticized Supreme Court, saying that Supreme Court is not having the judges, the Chief Justice of Supreme Court is a mad person, I am the better person, and he was saying so many things. So the Supreme Court has taken that particular activity as contempt of court, and right now that particular person is in jail. So it is an example of contempt of court. Now the contempt of court can be taken into account under civil and criminal cases, and If you are booked under contempt of court, then what will happen? You will be punished. Now, what is that punishment? You are a little bit unlucky, then you will be put in jail for 6 months. Okay, simple imprisonment of 6 months. Or if you are very much lucky, you are doing puja, that and this, and you are very much lucky, then you will be imposed a fine of 20,000 rupees only. If you have money, you can just pay it. Scratch the card and say that Digital India Jindabad, and just get out of all that mess. But if you are too unlucky, you are the worst fellow, then what will happen? You will be imposed 20,000 rupees fine, as well as you will be put in jail for 6 months. Okay, so such is the punishment regarding contempt of court. So let's move on to the next power of Supreme Court. Now here comes the exclusive power of Supreme Court, that is the power of judicial review. Very important. The power of judicial review is very important. Now what do you mean by judicial review? Judicial review is nothing but it is the power of the Supreme Court to examine the constitutionality of a particular legislative enactment, that means a law made by any central or state governments, or otherwise the executive orders that are being issued by or given by the central government or the state government. Those particular legislative enactments or executive orders can be examined by the Supreme Court so as to analyze the constitutional validity of those particular legislative enactments and executive orders of central and state governments. Okay, so if a person feels that there is a particular law and that particular law is in some way is against the constitution or just violating the issues mentioned in the constitution, then that particular case will be brought into the notice of Supreme Court. Now when that particular issue is brought into the notice of Supreme Court, then it will examine whether that particular legal enactment or the law or the executive order is in lines with the constitution or not. And if the Supreme Court found that that particular law is violative of constitution, then it will declare that particular legislative enactment or executive order as ultra vires. That means it will be declared as illegal, unconstitutional. Okay, and it is also called null and void, which means unconstitutional and invalid. So such power of Supreme Court of examining a particular constitutional validity of a particular issue, and if that particular issue or order or law is violating the constitution, then it will be declared as illegal or unconstitutional. In such a case, that particular law or order cannot be enforced or implemented. Such is the power of judicial review which the Supreme Court has. And it is another issue that Supreme Court and other courts are using judicial review as a tool of judicial overactivism. And what do you mean by judicial activism and overactivism? We will discuss that particular issue in another lesson, okay? But the issue is that judicial review is an active and superb power in the hands of Supreme Court. Okay, have you understood judicial review? And another important issue is that this particular judicial review is nowhere mentioned in our constitution. Okay, judicial review is nowhere mentioned in our constitution. That means it is mentioned implicitly, not explicitly. That means somewhere in some article judicial review is mentioned in clear terms, but nowhere it is mentioned that it is called judicial review. We are calling it as judicial review. Actually, in our constitution, article 13, which article? Article 13 as well as article 136. These two articles are having some provisions which are similar to this particular issue of examining the constitutionality of laws and executive orders of central and state governments. So this particular issue is mentioned in both these articles, which we call as judicial review. But nowhere in our constitution the term judicial review has been used. Is it clear? Now let's move on to the next important issue. So the provision of judicial review is given in our constitution, but why? What is the need of judicial review? Why we are having something called judicial review in our constitution? There are certain reasons. The reasons are that so as to uphold the supremacy of the constitution, that means no government or the public authority has the power to override the constitution. Okay, to do so, judicial review, the provision of judicial review has been put in our constitution, and to maintain the federal equilibrium, that means the same powers the state and center should have. Neither the state nor the center should have the power to change the constitution in their favor. Okay, as well as the citizens are being provided with fundamental rights, and there may be situations where the state have the power to violate the fundamental rights of the citizens. In such a case, it becomes the duty of the Supreme Court to protect the fundamental rights of the citizen. So judicial review is the tool given to Supreme Court so as to protect the fundamental rights of the citizen. So the founding fathers of our constitution has included this judicial review issue in our constitution for these particular 3 issues. Is it clear? Now, is there any incident when the power of judicial review is used by Supreme Court? Yes, there are many incidents. In 1963, what happened? The Supreme Court used the judicial review power and decided the case which is called the Golaknath case, and the similar case is Keshwanand Bharati case, which took place in 1973. And in 1970 also there was a case, that is bank nationalization case, and in 1971 there was Privy versus abolition case. All these cases, and there are so many examples where the Supreme Court has exercised the power of judicial review. Okay, and as I have mentioned earlier, that judicial review is nowhere mentioned in our constitution. Is it clear? So this was all about judicial review. Now let's move on to the next one. There are some other powers of the Supreme Court which are mentioned in our constitution in different parts of our constitution. Those powers are that the Supreme Court has the power to decide the disputes regarding the election of our president and the vice president. Any issue regarding the election of means any dispute regarding the election of president and vice president is there, then such a matter can be brought into the notice of Supreme Court only, and the Supreme Court has the power to give its judgment, and that particular judgment of Supreme Court regarding the disputes of president and vice president is final, exclusive, and it has the original authority. That means it has to be implemented. Is it clear? Then in the same way, the Supreme Court is also called as self-correcting agency. Now what do you mean by self-correcting agency? Self-correcting agency means the Supreme Court has the power to review its own judgments or orders which has been given earlier. Let me give you an example. Earlier in 1970s, when the issue of right to privacy came, that whether right to privacy is a part of fundamental rights or not, then the Supreme Court said that no, right to privacy is in no way a part of fundamental rights. But now in 2007, Supreme Court is saying that right to privacy is an integral part of fundamental rights. That means Supreme Court has corrected its judgment. Okay, why it has done so? Why this particular power has been given? Because at one point of time, according to the social situations, according to the economic situations, the cultural situations, it may be legit and justiciable to maintain a particular law. But at a later point of time, when the conditions have changed, the technology have changed, the social and cultural conditions have changed, in such a scenario, that particular law which was legit and justiciable once may not be justiciable now. Is it clear? So it has the power to change its own decisions. Is it clear? Then, as well as regarding the conduct and behavior of chairmen and members of UPSC, can be inquired by the Supreme Court if the President of India refers for that particular purpose. Okay. Then at the same time, Supreme Court of India has the power to withdraw any case that is pending before the High Court, and that particular case can be disposed of by the Supreme Court itself. And as I have mentioned earlier, I have given the example of Jayalalitha's case, that any case can be transferred from one court to another court within India, and that power is with Supreme Court. Is it clear? So this is all about this particular chapter, that is powers and functions of Supreme Court. I hope you all have understood this particular lesson. If you have any doubts, please mention your questions in the comment box. I will reply you. And if you have if you think that this particular lesson have helped you in any way, then please hit the like button. It will be a great encouragement for me to make some more videos and help you people to learn so much, and it will be an opportunity for me to share my knowledge with you all awesome people. So enjoy your life while doing what you love. So do your work with passion and dedication. Definitely you will win one day. You are the rulers of your life. You are the creators of your destiny. So work hard now. Put in all your 100% energy and work hard. Focus on your goal. Definitely you will reach your goal. All the very best. Hit the like button if you have liked, and if you think that I should improve myself, then mention it in the comment box. Thank you so much.